Welcome everyone to the latest installment in our Understanding Agricultural Law educational webinar series. Today we're going to talk about the basics of leasing farmland for energy production. This webinar series, our goal with it is to address various agricultural law issues for attorneys and other professional advisors for farmers and agribusinesses. And we're conducting this webinar series as a partner with the Pennsylvania Department of Agriculture's Agricultural Business Development Center, and we're pleased to have with us the director of the ABDC, Phil Stober. So I'm going to turn the floor over to Phil to say a few words about the Ag Business Development Center.
Great, thanks very much, Ross, and welcome everybody to today's seminar. We're really glad you're here. So Agricultural Business Development Center came out as a result of the 2019 Farm Bill. And basically what it's designed to do for the ag community in Pennsylvania is to help people with, sound business planning, transitioning farm ownership, either from one generation to another or transitioning from conventional farming to organic farming. We have a lot of beginning farmer support, both technically and financially. We help people with strategic expansion planning, helping people diversify production, and then, of course, expanding capacity and access to the ag community, to ag professionals. In today's case, the legal profession. As you all know, everybody needs a good lawyer, and so do farmers. So that's what we're trying to do with this 12-part and hopefully a further ongoing series of seminars on various issues that the law profession is going to have to deal with ag in the ag community. So I will turn it back over to Ross and Brooke, and thank you again for coming. And remember, if you have any clients who are in need of any of the things that I suggested, please have them contact me at the Agricultural Business Development Center. And thank you again for participating today. Thanks.
Thanks a lot, Phil. No. And as I mentioned earlier, this is the second webinar. We last month we talked about agricultural labor laws. Next month we're going to be talking about land use, and then we will shortly we will be developing the schedule for the following fiscal year beginning in June. These topics, these first three topics, and likely some of the early topics in the next fiscal year are going to really be looking at kind of the basics of a number of topics. As we move forward, our intention is to continue to cover the basics of some topics, but also to drill deeper into some more specialized topics. So we will have a bit of a mix of topics at a kind of an overview where we're covering a lot of ground, and then we'll have other topics where we're really drilling down into a pretty narrow topic. Just for those of you that may not be familiar with the Center for Ag and Shale Law, I'm just going to run through some of our work product in the next few slides. I would encourage you to check out our website. The address is aglaw.psu.edu, and all of our resources are contained on that site. If you look at the menu bar that you can see on the screenshot of our website now. The events tab is where you can find information about all of the events that we are presenting or that we're participating in. The screen now shows you our Agricultural Law Weekly Review, which is a work product that we produce each week that highlights developments from the past week. So you can sign up to receive that via email, or you can go to our website and check that out. You can see on the right hand side we have links to our social media. We also have under the research by topic page or section, we have some what we call virtual resource rooms, where we take a particular topic and provide you with a number of resources in that topic. Also on that research by topic, we have what we call issue trackers, where we take a topic and provide a kind of a running list of legal developments related to that topic. So if you want to get yourself up to speed on a particular topic, the tracker is a way to do that. We also have podcasts that that a lot of the content from the weekly review is then kind of translated into a different format if you prefer to receive your content through podcasts. Also, we administer the Pennsylvania Agricultural Mediation Program, which is funded by USDA and provides mediation services for a number of areas, including disputes with USDA, with program participants that have received some type of adverse action from USDA. Okay, so some ground rules for the or some kind of housekeeping for this program. We are recording this webinar. We would ask that if you have any questions that you use the Q&A feature. For the Pennsylvania attorneys that are looking for CLE credits, there is one CLE credit available for this program, and there will be a link that either is posted or will be posted shortly in the chat for you to complete to get your CLE credit. So please fill out that form. I will be giving you a code word. We're required to verify attendance, and so the use of the code word is the way that we do that. So at some point during the presentation, I'll provide a word that you can fill into the CLE form that verifies your attendance. And if anyone has any questions, please email Jackie Schweichler at jks251@psu.edu. Okay, so for our program today, we have an hour. We're going to this is an example of covering a very broad topic in a short amount of time. What we're going to do is we're splitting up. Brooke and I are splitting up the presentation. I'm going to start by talking just a couple minutes about energy generally, just to provide some context for the rest of the program. And I'm going to spend the bulk of my 15 minutes talking about natural gas leasing. Then I will hand the program off to our staff attorney, Brooke Dewar, who is going to talk for about 30 minutes. And he's going to spend, almost all of his time talking about solar. He'll talk for a minute or so about wind at the end. But so most of our topic is going to focus on natural gas leasing and solar development. And then we'll hopefully have some time for some questions and answers at the end of Brooke's presentation. Okay, now this just to start by talking about energy generally, to provide some context for our program today. I love this slide. This is kind of a picture of the U.S. energy system, or the energy that we consume in the U.S. The Lawrence Livermore National Laboratory puts out this graphic each year. They do it for states, for other countries, and as you look at it, you can see there are 9 sources of energy on the left. And so this tells us this is where the U.S. is getting its energy. And then you can follow each energy source, you can follow it through the chart to its end use. So you have the energy production or the types of energy that we're using. And on the left side and on the right side, you have where or how we're using that energy. And I think this really, it provides a graphic illustration to show how all of the various energy sources work together, how they compete with one another, that, when you have a particular legal development or a policy development, you can really kind of get a picture as to why certain other energy or stakeholders of other energy sources have an interest in that particular legal development. Now, when we're talking about ag or farmland, as you look at the types of energy sources on the left, you can really see the strong relationship between agriculture or ag or farmland and energy based on where where these particular types of energy are being produced. So just to kind of walk through the left side, solar. We're seeing a lot of solar development or a lot of interest on farmland for solar development. Similarly, as you work down through that list, wind. I mean, in a number of not so much in Pennsylvania, but a number of places we have wind development on farmland. Continuing to move down, natural gas, as we've seen in Pennsylvania, a lot of gas development is taking place on farmland. Continuing down the list, biomass. We're talking largely about corn-based ethanol. Again, not a huge issue in Pennsylvania, but nationally, when you talk about farmland and agriculture, obviously corn-based ethanol is a huge issue. And then moving down to oil production, which also in some places is taking place on ag land as well. So as you look at energy and agriculture, we often in energy, when we're talking about energy systems, we talk about upstream, midstream, and downstream to describe what is taking place or where it's taking place in terms of the overall energy system, and the use of the term upstream to refer to, excuse me, where the energy is actually being produced. So, with agriculture, we have, if we're talking about upstream in the energy system, we have agricultural commodities such as corn or soy that are being used in the energy system. We also have agricultural byproducts such as manure or animal waste that's being used to in a digester to produce energy. And then we also have an awful lot of agricultural land that is being used for the various to produce the very energy from the various sources. We also have a huge agricultural component in the midstream sector. When you think about natural gas pipelines or oil pipelines or electric transmission lines, those are all part of the midstream system, and they have, often are impacting agricultural land or are being installed on agricultural land. And then downstream, when we talk about the distribution or the ultimate users of energy, agriculture is a huge user, from fuel and electricity to other inputs in the agricultural system that are really energy related, such as fertilizer or pesticides. So there's a huge connection between agriculture and our energy system. Now, shifting gears to talk about natural gas development, and just to provide kind of a snapshot of where we are right now in terms of production. The monthly drilling productivity report from the U.S. Energy Information Administration came out earlier this week, and so this shows you some data from that. You can see what's indicated as Appalachia, which the map on the right of the screen kind of shows you what is referred to when they say Appalachia. But basically, we're talking about the Marcellus and the Utica shale formations. You can see still by far the largest producer of natural gas in the country. Now, when we kind of zoom in at the Appalachian region, which is again Marcellus and Utica formation, and to look at over the last decade what's been going on, you can see that a large increase maybe turning into a more gradual increase, but even up to the present time, we're still seeing an increase year over year. Now, moving to the graphic on the right, if you focus on the black line, which shows the rig count, you can see that is very much a roller coaster. But at least over the last couple years, it has been somewhat steady to maybe increasing a bit. Now, if we look just at Pennsylvania and look at the historic data for production in Pennsylvania, you see a huge increase since 2010. And when you look at the chart at the top of the screen showing the production year by year, I mean, we're still seeing a fairly substantial increase each year. This morning I calculated, I think from 2021 to, or from 2020 to 2021, it was about a 7.5% increase. I think 3.5% the year before that, about 10% the year before that. So we are, even though there isn't as much discussion, or natural gas development isn't maybe as taking as larger part of the public discourse, we're still seeing a pretty significant increase, ongoing increase in natural gas production in Pennsylvania. Okay, now to talk about some of the legal issues. And when I think about what are the issues, if you're an attorney or other professional and you have someone that comes in your office that has some natural issues related to natural gas, I mean, these I think are the four types of issues, or the four categories that they're most likely to present to you. And the first issue would be kind of the lease formation, where someone has been approached to sign a lease, a new lease, or maybe the lease is expired and they're looking to release that. That certainly is a big issue, and not nearly to the scope as it was a decade or more ago. But there still is leasing, and there will always be some leasing at some level. It's going to be a lot more focused than it was 15 years ago, but that I think is still an issue that you need to have familiarity with. The second question deals with the ongoing validity of a lease. So if you have a lease that was signed 2 years ago, or 5 years ago, or 15 years ago, or 75 years ago, you may get the question of, well, is this lease still valid? The third issue I think that you're likely to be presented with deals with the use of the surface estate. When you have multiple individuals that have some right to use the surface estate, how do you deal with the interplay among that? And then the final issue deals with royalties. When development is taking place and the landowner is being paid royalties, there often are questions generally focusing on deductions from royalties that I think you want to have some familiarity with. Now, in the interests of time today, I'm going to focus on this second and the third bullet point. Now, there's a lot of material in that first and fourth bullet point. Certainly, I'm open to feedback from you all if you're interested in having us do additional programming on those topics. But I'm just going to spend the next few minutes that I have talking about ongoing lease validity and surface estate issues. Okay, so the determination of whether a lease is still valid or how long that lease is going to last, I think really you need to start with the so-called habendum clause in the lease. The habendum clause is the name of that clause that states the duration. And I have an example on the screen. This is a very, very basic example of a habendum clause, one that would state this lease is valid for 5 years and so long thereafter as oil or gas is produced from the property. Okay, the habendum clause of a particular lease is probably more involved with that, or more involved than that. But at a basic level, the habendum clause that I have listed illustrates, the so-called primary term and the so-called secondary term, and those are the two components of that habendum clause. So the primary term here is the language stating that the lease is valid for 5 years. So that is essentially giving the lessee, the company that has paid money for that lease, it's giving them a time period of 5 years, kind of an option in some respects to develop that property. And then the secondary term goes on beyond that. So if the lease is going to be valid beyond that 5-year period, there's going to be a requirement that oil or gas is produced, or the lease is going to be valid so long thereafter as oil or gas are produced from the property. Okay, so if you want to look at whether a lease is still valid, if you're in the primary term, you need to look at really the delay rental payments, and have those delay rental payments been made in most cases exactly as stated. Now, I think you also need to look, and this would be outside of the habendum clause, but to look at if there is an extension term that would allow the company, either with payment or without payment, to tack on it more time. So basically, if it's a 5-year habendum, if the habendum clause has a 5-year primary term, does the lease have a provision that says the company can extend that for another 5 years? Now, when you're in the secondary term, generally, you have to have actual production. There has to be production of oil and gas to keep that lease valid beyond that primary term. Now, where this gets a little tricky is actual production is required, but it's possible that you can have constructive production. It's possible that you can have something happen that provides a substitute for production, constructive production. And that can be provided by the lease, or it can be provided by a common law doctrine. Now, what are some of the common substitutes for production? You could have a shut-in royalty clause. So if the well is able to produce it, but it is not producing, maybe there's not pipelines in place, maybe there's some other reason that the well is shut in and that payments are being made according to the lease, there's no production, but that's a substitute for production. There also could be a temporary cessation of production, and I'm going to talk more about that here in just a minute. But if you have production that stops, depending on the circumstances, that may be a substitute for production if it's a relatively short, or historically, if it's a relatively short stoppage for a reason that's outside the control of the producer. You also can have an operations clause or dry hole clause that will allow the oil and gas company to continue drilling in the secondary term when they have started drilling within the primary term. You also could have force majeure, and you could have pooling, where there's a well on another property, but the subject land has been included. Now, there are two statutes that I think you need to be aware of relative to this discussion. And the first statute was enacted in 2014, and it provides a process. So if you have an old lease that's on the record, but is not valid, this provides a process for a landowner to go through to put something on the record to help to address the cloud from that title. And then in 2017, there was a statute that kind of provided a little bit more definition to what temporary cessation means in Pennsylvania. And the bottom line of this particular statute, which I'll highlight, is in Title 72, not Title 58, states that if there has been no activity on the property and a landowner gets a royalty check and they accept that royalty check, or if there is a new well that is drilled and the landowner has provided notice and they don't object, that gap prior to that will be considered a temporary cessation of production. So it means that lease is still valid. So if your landowner, if your client, gets a royalty check after a well has been dormant for a while, they need to know, they need to get advice before they decide whether to cash that check or not. Okay, now just a couple words about surface estate. If you have an issue regarding surface estate, Belden and Blake versus DCNR, Pennsylvania Supreme Court case from 2009, it's still the case you need to look at. And the basic facts: we had a split estate situation. The state owned the surface, the mineral rights were owned privately. Belden and Blake had authority to extract oil and gas. DCNR would not let them come on to the property unless they signed a coordination agreement. Belden and Blake said, we don't have to do that. We have an implied easement to use the surface estate. The Supreme Court agreed with them. And I've kind of bolded what I think are the two important takeaways from this case. One is that the subsurface estate is dominant over the surface estate. and that the subsurface estate owner is entitled to reasonable use of the surface estate. So it is an easement. The subsurface rights holder has an easement, but it differs from a traditional easement in that you don't have specifically delineated boundaries for that easement. It's across all of the property, and it would be based upon what's considered to be reasonable use. And so when you think about a situation where you have the surface and the subsurface held by one party, and that they have leased the oil and gas rights, what's the interplay between all of these other various sources of rights that can be granted? An agricultural lease, a solar lease, which Brooke is going to talk about. And so you need to recognize that if someone has signed an oil and gas lease, that if they sign a lease, an agricultural lease or a solar lease in the future, they're granting those rights subject to the rights that they have already granted. And so, think about the interplay between all of those various rights to the surface estate that have been granted or that could be granted. Okay, so I'll give you the code word and then I'll turn it over to Brooke. The code word is energy. So fill in the word energy in your on your attorney CLE form. And with that, I will stop sharing and turn the program over to Brooke.
All right, let me get myself all situated here. We are right on time, so now the pressure's on for me to not run over. All right, hold on a moment. I think we're sharing. Let me just go to the presenter mode. There we go. Okay, so here's the title of my presentation is Solar and Wind. However, I'm going to primarily talk about solar, as Ross referred to. And I've learned a bit about wind myself in getting ready for this, mostly that most of the issues are pretty much the same in a wind context as a solar context, not entirely, but for the purposes of a small, short presentation like this at a very high level overview, most of the things I'm going to say about wind, about solar, more or less apply in the wind context also. All right, here we have a depiction, of course, of a solar facility that is designed to supply electricity to the grid. And that's primarily what we're going to talk about. But there are different types of solar facilities. So let's go through and make sure that we have sort of differentiated between them and we understand what we're talking about. There is, and I'm just going to use the terminology behind the meter and in front of the meter, and then explain what those are. Behind the meter is referring to rooftop systems or other types of locations. They can, of course, be on the ground mounted also, that serve a single user, which may or may not involve some degree of net metering of excess electricity back to the grid. In other words, there could be some grid connections or some grid supplying back through the meter, so to speak, by that single user. And that's obviously been something that has existed for a long time in Pennsylvania and has been through a lot of regulatory hubbub, let's just call it, in the last couple of, maybe the last 10 years or so with regard to the PUC regulations of net metering, because in that case, there is a role for the power company to be regulated with regard to what the customer is being paid for that excess electricity that is being sold back to the electrical supplier, so to speak, or the electrical utility. Now, in front of the meter is also called distributed generation. And if you just picture it, it's in front of the meter before you get to the meter at the individual customer's home. Distributed generation means that it's electricity that's being generated and then distributed in some way to multiple persons. So that's why distributed generation is another term for in front of the meter. There's two kinds, more or less, that are we see prevalent today. One is community solar, which is not legally authorized in Pennsylvania presently. So while there may be a little bit of leasing activity going on out there for community solar, we do not have this legally authorized to occur yet in Pennsylvania, but there is a little bit of leasing. What that means is essentially, I like to use the word a subscription service, because it is essentially constructing a system amongst multiple, or it's put it this way, it's constructing a system and then soliciting subscribers to purchase their energy from the operator of that community system. So you might have 350 people in a particular township that are part of a community solar facility that might be produced, have panels at a certain location, and it's producing this electricity. And then that operator of that particular solar facility is essentially generating electricity for the grid, and the subscribers are essentially paying that person as their electrical provider, or paying that into that community solar facility. So that's what community solar is. Someday we may have that in Pennsylvania, and it has been the subject of several attempts in the legislature. There is a bill now pending, but none of those bills have proceeded anywhere close to being passed. Now, grid scale or utility scale solar is what we're here to talk about. That's the major leasing activity that we've seen across the state, and that is, let me just advance my slide for a second here. I have to get there we go. Okay, so that's what we're going to talk about, and that is basically photovoltaic electrical generation for the purpose of wholesale sale of electricity to the transmission grid. So a private solar developer secures acreage by a lease, which is what we're seeing a lot of, or they can come in and just be purchasing ground to do this. There's reasons why they don't do that, and we'll talk about that, upon which they install a solar array, and they essentially set up shop generating electricity and selling it to the grid. It's kind of like, I'd say it, I don't mean to be flippant about it, but it's an instant power plant. You build the facility, just add land, and you are in the power generation business. Not nearly as complex, perhaps, as many of the other power plant operators and facilities that we're aware of, whether it be nuclear, whether it be coal burning or gas burning or whatever that may be. So this obviously costs a lot of money, however, and in that sense, it is just like other electrical generation systems. The interesting thing about solar, where we are right now in Pennsylvania, is that there is no regulatory role of the Pennsylvania Public Utility Commission, and there are no uniformly or universally applicable state laws that specifically control this activity. They control the ancillary activities that go on in connection with building one of these and potentially operating one. Things like stormwater management, erosion and sedimentation controls during the construction, electrical code compliance with the actual physical facilities that are being built. All of those things, yes, are legally regulated by the mechanisms that are already in place. But the actual activity of siting, building, and operating a solar facility for grid scale generation is not regulated by the PUC or anyone else. So whereas we had, of course, DEP regulating gas drilling when we went through, the leasing boom, a decade plus ago, that is not something we have now. We do not have that single point of regulatory contact from the state government. So this is really a private land development, the siting of which is subject to essentially the exclusive jurisdiction of local municipal government through all the normal tools, zoning, land development ordinances, et cetera. And that's a somewhat unique circumstance. Now, there is a federal government regulatory role, and I want to talk about this real briefly because it helps to understand where the leasing fits into the whole process here. There is a federal role, a regulatory role, through what is called a regional transmission organization, which is essentially a group of electrical generators, electrical production utilities who have pooled their resources and pooled their or pooled their cooperation, let's say, have agreed to cooperate with each other in the formation of a regional transmission organization that then is the governing body for the grid, the electrical grid, for an entire geographic area. And you can see a little map here that shows you the grid, the RTO, the Regional Transmission Organization that we are in Pennsylvania, is called the PJM Interconnect. And here's the map of all the states that it contains and parts of states, all the way out to parts of Illinois, all the way down into parts of North Carolina. So it's quite large. And the urban environment that we're talking about here, that this services is quite well populated. Let's just put it that way. This includes, of course, Washington, D.C. and Philadelphia, and large masses of energy consumers, so to speak. So the interconnect then answers to the Federal Energy Regulatory Commission, FERC, who is most well known to most people, and their jurisdiction is to regulate electrical utilities as a portion of what they do, who are engaged in interstate transmission of electricity. So that's the string essentially of regulatory authority. So the PJM Interconnect becomes the real depository or repository of all the information about all the projects that are going on at a particular time. The Pennsylvania state government could not tell you how many solar projects are under development in Pennsylvania right now, because they have no repository for that information, because there's not a permitting system or some type of a filing that has to be done in order to proceed with one of these. The PJM is where you get all that data about what is actually going on in Pennsylvania. And here's a piece of that data, which is, this shows you, they have all sorts of great information on their website. This is just a reflection of how many solar projects are proposed to be built within the geographic bounds of the PJM Interconnect. So as you can see, it's quite voluminous. Now, this is a little timeline of a project going through from beginning to end with regard to, and this is more or less to illustrate the PJM steps, let's say, and then the local government steps, let's say. This is not really a timeline of a lease. We'll have one of those a little bit later. But this kind of shows you, you have initial PJM review, on the far left, final PJM review, project design, then you have construction, and then you have the operations phase when you're actually generating, or when the developer is actually generating electricity. And there are numbers in here, and I want to go to the second little timeline at the bottom, which those are numbers from the fall of 2021. So they are certainly not exactly accurate today, but they give you the idea of the distribution of projects along that path towards completion. The most important part about this is over in the far bottom right corner, you see 461 projects. That is just Pennsylvania. That's not that entire map that we looked at a minute ago. That's just Pennsylvania, are in this PJM queue, is how it's referred to, but only single digits, and 7 is not the number anymore, but it might be 8 or it might be 9, but the number of projects that have actually been completed and generating electricity remain in the single digits. So that gives you an idea of where this industry is in its larger development process. We are so far from seeing a mature industry. As I always say, this is an industry that is completely in its infancy at this point in time. Now, let's talk about the leasing process. And by the way, let me go back for a second. The leasing process, and what we're going to talk about here, is basically all in this in this beginning stages on the far left. When an option to lease is entered into, then the PJM application is likely filed at some point after that. So what we're going to talk about from now on is way, essentially to the left of this little timeline. Now, the leasing process, leasing versus purchasing. Again, I said before, this could all be done by simply the solar developers coming in and purchasing land. Why are they leasing? Well, they're leasing because they can't really, or they don't wish to make the economic commitments to purchase the land until they know that a project is a go. And the engineering, this process of getting the electricity to the grid from a particular site that is under lease, very complex. There's all kinds of economic decisions that have to be made about what's a viable project and will it be, economically advantageous to build at this location. So not every site is going to work. However, they are going about the process of leasing property in order to get sites under lease, or at least under lease options. We'll talk about them in a minute, and then essentially engage in a long process of multiple years, sometimes figuring out what combination of properties works depending on all the site conditions, and most importantly, what type of obstacles and what type of distance do they have to travel with this electricity to get it to the grid. So usually it's multiple properties packaged together who are trying to appreciate some type of economy of scale in transmitting the electricity from the sites of the solar arrays to the grid. Obviously, being close to the grid is the most important and most advantageous aspect of any particular site. So that's where they're looking first, or that's where they would be prone to look first, because that's the cheapest way to build and operate a project. So there's so many variables. This is a numbers game. It is essentially a numbers game of signing up a lot of properties and then figuring out exactly how you can put together a project that is going to make economic sense. So that's why optioning to lease fits the bill for what they're engaged in right now. Otherwise, they'd have a lot of land that didn't pan out that they would have to then get rid of if they were going on a buying spree across the state. Now, what we're going to look at here is that, we're going to talk about a generic example of a grid scale solar lease relationship. Every particular circumstance and solar developer who's engaged in this right now, and many of them, there are small entrepreneurial operators. Some are large. There'll be a lot of turnover in this industry as it goes forward. Many of them are in this to put together packages to sell to others who might be the ultimate operator. There's a lot of things going on here, but we're just going to look at sort of a very generic structure of the lease. Okay, you have two pieces to a solar lease when a landowner is approached. First is the option agreement, and then the lease agreement. Option agreement is just basically what it sounds like. It's an agreement to exercise an option unilaterally by the developer to go ahead and enter into a lease. So the important thing about this is, of course, the landowner is agreeing to the option, and attached to that is the lease itself. And so they're agreeing to the entirety of the lease terms as attached as an exhibit when they agree to the option. There's no going back and saying, oh, you know what? Now that you've exercised the option, I think I need some changes here, some changes there. That's not the way this industry is rolling out. It's a unilateral option to be exercised by the developer only. Once the landowner signs the option agreement, they are committed if the developer wishes to proceed, and they are committed to the exact terms in the lease agreement that have been attached as an exhibit to the option agreement. So that's a huge decision. Some of these agreements are lasting decades. Sometimes there's a little preliminary letter of intent, which is mostly just to try to get somebody to sign a confidentiality clause so they're not talking to their neighbors about what kind of money's being offered. These letters of intent, if you're an attorney and you've seen and dealt with this type of thing many times, simply non-binding, but attempting to at least lock in a confidentiality with regard to negotiations. Not to say that it works all the time. A lot of neighbors are trading their numbers and talking to each other. Now, here's the timeline of the lease agreement. You have the option phase, which is after an option agreement is signed, and that's really their developer's due diligence period. Then once you have an exercising of the option, then you have the lease. Essentially, it's a really quick turnaround time, the way these things are drafted. The developer basically says, okay, if I decide to exercise this option, I'm going to give you X number of days to turn it back to me with signatures. Or they might even get a signature on the lease agreement ahead of time. And then you move into the construction phase. Oh, and by the way, the option phase, again, that could be multiple years when that not only could it be multiple years to complete the project, but it could be multiple years just essentially scoping out the project. Once the option agreement is signed, these can be 4 or 5 years long sometimes because they have a lot of juggling the developer does to figure out what's going to work or not. Then you get in a construction phase where they're going to do their build out. You obviously get paid for the exercising, or excuse me, you get paid for signing the option. I'm not going to really comment upon payment amounts and what's a good amount. That's sort of a whole separate discussion. Then the construction phase starts. You should negotiate for your client to get paid during that, if in fact it's not in the lease agreement that ultimately becomes enforceable. Then there's the operational phase, which is once the switch is turned on and electricity is being generated, and that's the full rent period. That's obviously the most lucrative time in terms of getting rental payments from the solar developer. And these are usually in increments of 10 years, and there may be a series of 10-year extensions. And these things can run 20, 30, 40 years long once you're into the lease itself. And then there's a decommissioning phase, which is essentially restoring the land back to its pre-development phase, so to speak. And there's a lot of concern about that everywhere because of the fact that this may be happening decades from now. Now, in the option agreement, again, it could be anywhere 1 to 5 years. It's essentially their due diligence period where the solar developer is looking at essentially a feasibility study to see if it works. They're going to do all the title work possibly, can be done with regard to the property, surveys, et cetera. Farmers, for example, can still farm the land. They're still in primary possession. They grant some minimal, possessory rights to the developer to do their due diligence, so to speak. So that's essentially the option period. The lease period, then once that the option is exercised and the lease is now in effect, there's no turning back, no chance to renegotiate. And this is really just what would have been in the old days called, a ground lease, just a very extremely long lease for ground in order to do, the thing that is perhaps most unusual, at least to a layperson about all this, is that they're building multi-million-dollar structures on land that they don't own, on somebody else's land. And when I say multi-million, I'm talking hundreds of millions. There is an equation that talks about $1.13 million of investment to generate 1 megawatt of electricity. And some of these projects are, can be 50, 100 megawatt projects. That they can be even larger. So, these are, tens, if not hundreds of millions of dollars in upfront investment to get one of these projects up and running, depending upon the size. Now, the most important consideration from the landowner's perspective is to think ahead about all of the competing legal interests that may have already been granted, just like Ross was talking about with gas leases, you have, issues to consider about who has already received benefits by some legal instrument, or I should say has received legal interest in the property by some legal instrument, such as a mortgage, et cetera. And so you have to figure out how your land is encumbered to figure out how, whether a project is going to work or not. So that's an important consideration. And that's a large part of the time that's used during this due diligence period, is figure out whether these competing legal interests are going to cause a problem with the uninterrupted flow of electricity from the site, because that's the one thing that the solar developer cannot have now that it has invested hundreds of millions of dollars potentially, is some type of title problem or some type of other rights holder emerging saying, hey, I have rights to explore for gas here, or whatever it may be. Who's the most important competing legal interest? Your mortgage. And I think I have a slide that, there's the mortgage. I'll get to the mortgage in a minute. Other types of competing legal interests, hunting leases, obviously they don't want stray rounds bouncing off of these panels. Subsurface rights, again, just what we talked about in terms of, gas rights holders showing up and indicating, they're ready to start putting a road in and dig right through the panels. So obviously you can't have that. Any other types of existing easements, enrollment in government programs can be competing legal interests. The Clean and Green tax assessment program, solar development for the grid is not a permitted use on clean and green enrolled property unless 50% of the generated power is used on site, which is not going to be what you're dealing with in a grid scale situation. So that is going to be a very significant consideration, because you're going to have a rollback tax if you're in clean and green and you have leased for solar development, and that leasing goes forward. Other types of things like Farm Service Agency and NRCS conservation programs, those are all going to be individual answers from those programs with regard to the terms of each one of those programs. But likely answer to all of that is that's a no-go. In other words, this would not be a feasible use to layer on top of some type of other, particularly NRCS conservation program. That that issue may evolve over time, but right now that's the status of it. Same with agricultural conservation easements and most privately purchased conservation easements. That's going to be something inconsistent with leasing for grid scale solar. Now, your existing mortgage, what most of these agreements say right now is that essentially a subordination agreement has to be signed between the mortgage holder and the gas developer, so that the gas developer's rights to, or excuse me, gas developer, the electrical, developer, the solar developer, essentially has to have superior rights to the mortgage holder in order to continue to generate electricity should there be a foreclosure on the mortgage. So right now, as it stands, although individual cases can vary with regard to the negotiations on that point and how the final resolution is, that's the basic place that you should go into these types of circumstances understanding. A subordination agreement of all superior monetary liens like mortgages will have to be executed so that the solar developer can enjoy completely uninterrupted ability to operate on the surface there without any interference from some other rights holder and some type of circumstance such as foreclosure. Okay, I'm going to try to move quickly here. And
if anyone has any questions, please put those in the Q&A using the Q&A feature.
Yeah, do we have any yet? Should I?
We have one question.
Okay. All right. I'm just about done. Okay, so that's the basic structure of a lease. Terms in the lease. Obviously insurance that is naming the landowner as an additional insured on the solar developer's policy, and also a very, very strongly worded indemnity provision are absolutely essential. And so those are obviously always the backstop to landowner protection, or the backstop for landowner protection in any leasing situation, and in particularly so in these circumstances. Most of the leases that you see at first tendered already have some of these things there, but you've got to read these things because they are not battle-tested documents where all the kinks have been worked out. This industry is operating, every company uses some different form, and these forms are all over the place. You got to be very, very careful when you're looking at them. I've seen lots of very obvious problems that should have been dealt with long ago if they had ever used this form with any frequency. Control and maintenance is obviously 100% on the developer. It's difficult to negotiate for some type of dual possession. And so you're really talking about, leasing an amount of acreage that's going to be in the exclusive possession of the developer with a fence around it. And, that's the way it's going to be. So if you want anything as a landowner different than that, you got to be very diligent to negotiate it all. There is possibility for things, but it's not going to come easy, and it's not going to be that fluid. If you're an organic producer, for example, you got to be careful about what they're using on the property. So there's all kinds of things to think about there. Now, one of the other key contractual provisions that everybody has been paying attention to in the last 9 months to year or so is decommissioning. The process at the end of this lease, whenever it may occur, to restore the ground back to what it was previously. And most of the leases that you see right out of the box as initially offered have some tip of the hat to decommissioning and make some commitments, but the way in which they make those commitments can be all over the map. Sometimes it's straight up bonding language. Sometimes it's other types of financial security. There's been a little bit of movement by the Pennsylvania General Assembly there have been 2 different bills introduced that are almost identical now, except for some specific points. And so the state legislature might actually get involved in an effort to protect landowners in the decommissioning process. The other thing, wind. I will say this, in researching wind, and I'll tell you this wind energy leasing handbook here by Shannon Farrell from Oklahoma State University, who's an attorney, runs sort of an ag law center in Oklahoma's extension service that is similar to ours, and Rusty Rumley, who works for the National Agricultural Law Center in Arkansas, who is a partner with us. They've written this excellent document, and I looking at that is your first stop. Essentially, as you read, you will see that the wind industry was really laying the groundwork for what we're seeing in the solar leasing area now. Many of the same exact issues, same exact concerns are all at play in the wind leasing situation. Here are a couple other nice resources. A lot of these resources are a bit older than the solar resources that you'll find out there because wind was up and running earlier than solar, and that has to do with some federal issues.
And Brooke, we have 2 questions, and just to highlight, the PowerPoint will be available on our website on the events page. The first question: if there is only an option agreement, is that considered an interest in land?
Well, yes. I mean, I guess for what purpose would be the next question. The option agreements are recorded. I've not seen anyone perhaps negotiate to not have it recorded. So the option agreement with the lease and everything, attacked as an exhibit, gets recorded right out of the box. So it's going to be recorded, that's for sure. So if that's the question.
Okay, and then the second question: are sureties issuing bonds for decommissioning?
That's a good question.
Available?
That's a very good question, and I don't know that anyone's quite seen one yet of the type that, we're looking for, which is to a decommissioning bond for a solar project that might not be called upon for 40 years from now. And I personally have not seen one yet. That doesn't mean a whole lot, because there's a lot of people out there in this industry who see a lot more documents than I would in our capacity. So that's a very, very good question. I think the surety industry, and I have a little bit of experience doing insurance litigation when I was a younger lawyer. I think that the surety industry, meaning the insurance industry, is probably going through an evolving assessment and underwriting analysis of what are they getting themselves into and what can they commit to and what won't they commit to. So I think that is a very, very good question. And I don't know that the answer is yes at this point.
Okay, I don't see any other questions. I want to thank everyone for joining us today. If you have any feedback or any topics that you would like to see us address in future programs, please let us know. And with that, we will end the program and look forward to seeing you at our next program. Thank you very much.